Okay, I get to talk about politics in the workplace. Here we are on May 12th, 2016. Some of you may be aware we're in the midst of a presidential election this year. Certainly generated lots of discussion, a lot you can't get away from it. And I've gotten calls from employers. Okay, we're in the midst of an election, a campaign, presidential cycle. Gee, is there anything we can do? Employees have their First Amendment rights. Is there anything we can do to keep things under control in the workplace? So let's go through this a little bit. So for recent survey, I should have credited the survey company here, but at the last polling data that I saw, substantial number of your employees are going to be talking about politics in the workplace amongst themselves, with their customers, with their suppliers, with their bosses, with their management. It's a topic of interest. Almost half your employees will expect to discuss the presidential election within the workplace. And more than 20% of workers surveyed said that discussing politics in the workplace leads to heated exchanges or fights between your employees. So what's the impact for you as the employer? We'll discuss, and then we'll discuss what can you do about discussions of politics in the workplace and not run afoul of any legal obligations or legal requirements. So the issues for employers include, you got a loss of productivity. This is in an unfettered, unrestricted workplace. If you've got employees coming in every morning, following Twitter, following the news, getting into discussions, you got people on one side, people on the other side, people in the middle. You're going to have a loss of productivity. You're going to have a loss of attention and focus to what you're paying your employees to do and what your employees are there to do, which is to advance the interests of the business. And you're going to lead to workplace morale. Because if your goal is to have a collegial work environment where your employees, together with management, everyone's working side by side, you're going to have some problems there when things get heated in the workplace over political discussions. Particularly, this cycle seems to be generating more heat on all sides than in the past. And when this spills out, if this spills out into discussions in front of your businesses, your customers, clients, even suppliers, you run the risk that your customer is going to be on to take a different view of the political discussion that your employees, your business may be putting forth. And people take these things very personally, very seriously. So you're likely to have an impact to your customer relations, which you don't want to have. So I get this question, I've gotten this question several times already in this campaign election from the people in charge of HR. Well, we've got someone who's wearing a button for this candidate or that, or someone who's got a sign, or someone who's coming in with a shirt, or talking about it in the workplace. What can we do? They have their First Amendment rights to discuss political speech. And the answer to that is, if you're a private employer, which most, if not everyone here is, the simple answer is no, they do not. There is no First Amendment right of your employees in a private work setting to discuss politics. There is no First Amendment right. First Amendment rights protect citizens against governmental action, either federal or state action. But in the context of private employment, your employees do not have First Amendment rights. So you can set, as the employer, you can set the parameters, either informally or formally through the issuance of policies. You can set the parameters and the boundaries of the kinds of discussions that your employees are permitted to engage in while in the workplace. Distinguish that, of course, from what your employees will do outside the workplace in their own private time, which you cannot step into that bound. And I'll come back to it later. Even the general rule that I just gave you about your ability to circumscribe and set the boundaries for what's discussed in the workplace has one exception, one or two exceptions that I'll get to. But that's the starting proposition. Your employees do not have First Amendment rights. And though they may come to you and say, you're infringing on my First Amendment right, you can gently tell them that as a private employer, they lose those First Amendment rights when they come into the office. Applies only to government action. Employees have no constitutional right to political expression in the workplace. And the same with political activities. Your employees do not have a right to come into work and display campaign literature, campaign slogans, T-shirts, posters, buttons. They have those rights in their private life, but when they cross the threshold of your employment, you have the right to say, you know, we don't want to have any political discussion or any political displays here. Employees do not have a right to solicit campaign contributions while at work or using your company's equipment. No right to wear campaign shirts, buttons, etc. But if you're going to do that, what you have to do is apply these rules consistently across the board. So your action and your managers can't say, well, because he or she may not like a particular candidate, you can't tell that employee you shouldn't be, and we don't want you to discuss that candidate's views or display literature from that candidate while someone's sitting somewhere else in the workplace who has a political expression that your manager agrees with is allowed to do that. So if you're going to do that, you have to do it across the board. Yes, Sean?
Now, is this on my property, or is this while clocked in? I mean, when we get into that lunch unpaid kind of game, do I have to worry about that?
No, on your property for sure, and even within your workspace. Once they come onto your premises.
Okay.
Like, so what you can't do is what employees are doing in their private life, as long as they're not representing your company, right? So that would be if employees are using company email account from their mobile devices that has a company's signature, a company block on the bottom, you have the right to restrict them from engaging in political activities under, to the extent that they're representing the company at any time.
So if he goes across the street for lunch, he can put his badge on and stand out there and shout for Trump.
Right.
When he comes back, if he's eating lunch on your premises, you can say none of that on my premises. Yeah.
So what are the risks to employers in this topic? So unequal enforcement, as I discussed before, this candidate you can talk about, this candidate you can't, can lead to claims of discrimination, harassment, or retaliation. And if you don't have a written ban on all forms of political activity, political campaigning, political expression in the workplace, you can have situations, and if your managers, your supervisory personnel don't observe that, the risk is that you can end up generating or having it lead to claims of discrimination. For instance, you have a manager that talks about, well, I support this candidate because he or she does not is a right to choose candidate, or he or she has a particular view about immigrants and building walls, or anything to do about immigration policy. Well, you have a employee who's working under that supervisor who then may feel that they're being harassed, or when some action is taken against them, it's because based on their religion, they may have a genuinely held religious belief that does not support abortion, or maybe a national origin, someone who is from another country who feels that this person, although in the guise of talking about a candidate, that candidate's position may implicate things that would be tied to protected characteristics such as age, religion, national origin. And so by me having those, just as having those discussions within the workplace, particularly, especially when coming from a manager or a company representative, you may be creating a hostile environment for employees who do not share those views. And then if there's any adverse action taken against those employees, you may have generated, given the employee the ability to assert, well, that person, I'm getting terminated or I'm getting disciplined because I don't share that candidate's views on these political beliefs that touch one of my protected characteristics. Discussion of political views may lead to claims of discrimination in the workplace.
I have a question.
Yes.
So at our company, a lot of the supervisors are Facebook friends with humans.
I'm sorry, I couldn't hear you.
A lot of our managers or supervisors are Facebook friends with just with their employees, their direct reports, and they might say, or they have said, I like Donald Trump, or or I like Hillary, or whoever, and I hear about it sometimes afterwards that like simply the direct reports don't like certain things. Can that be taken back to the office, or that's on Facebook?
Well, that raises a whole other, complicated issue about social media and the employer's right to regulate social media. What people are expressing in their private lives, such as on any form of social media, including Facebook, as long as they're not, attributing that or associating themselves with the employer, in other words, their Facebook page is truly a personal site, they have the right outside of work, I would say, as Larry, to communicate and express their political views as however they may want. The bigger issue is, and it's not necessarily a legal issue, but you've got the issue of should supervisory managerial personnel be socializing, and Facebook and Twitter, these are all social media, so it is a socializing environment. Should they be socializing with subordinates? And there's a whole, that is just ripe for danger on many fronts, because people tend to use social media to publish things about their personal life, photos, expressions of things that they want, including politics. So when you have a supervisor who is friends with subordinates outside of the workplace on social media, it creates the possibility of creating uncomfortable relations in the workplace. So that's not necessarily a legal answer, but I would certainly encourage supervisors and managerial personnel to be careful about their outside of work social relations with subordinates. But the specific question is, as long as the personnel are not affiliating themselves with the employer in their expressions of political views in their private life, even on social media, I don't think you have any ability to regulate that.
What about putting restrictions on them doing it during the work hours while they're working?
Yes, you can do. So certainly you can restrict employees' rights, ability to do that during the working hours. But someone goes home at night, goes onto Facebook and starts liking this candidate, reposting this candidate said, this candidate said. It's politics, right? It's going to lead to, by its very nature, to different points of view and disputes, and then the natural input. Then you have no way of barring that, those attitudes, the emotions of all that, the hard feelings then come into the workplace when you have co-workers sharing their views, sharing their social interactions. Tam?
Yeah, I just want to bring up at this point that the National Labor Relations Board has come down really hard on employers' restrictions of employee use of the internet and social media. And so I would just warn you to be very, very careful if you're limiting employee use of social media, to think very carefully about it, potentially to consult with counsel about it. Because under the National Labor Relations Act, employees have a right to what's called concerted activity, to talk about the terms and conditions of employment on social media, in emails, et cetera. It's the modern water cooler, and that is a right that people have because they have the right to discuss the terms and conditions of employment in order to potentially unionize. And so the National Labor Relations Board right now, in its current state, is interpreting this extremely broadly and making sure that employers give employees almost unfettered opportunities to use the social media for various interactions. There's a recent case in addition called Purple Communications, which says that although you can restrict employee use of your electronic communication system during work hours, you cannot restrict it during non-work hours. So we're getting into some very sensitive areas here. Certainly within what Gary's talking about, I completely agree with him about politics. But we need to be careful to give employees their rights with respect to use of social media and the internet otherwise.
So that's a great segue into one of the exceptions to the rule. So go ahead. Yes.
It becomes really challenging as the work life blends a great deal. So, we have employees that have flexible schedules. It's a challenge.
It is a challenge. It's a challenge for us as lawyers to try and make some sense and get some guidance and advise future conduct based on all the pronouncements of the NLRB. Their general counsel's office issues a report. They've issued several reports collecting their cases and their views on the use of social media in the workplace and what an employer can and cannot do. You can line up a number of those cases alongside each other, and it's very hard to find a consistent rationale, a consistent fact pattern that goes throughout it. So it is a challenging area. So it's an area that if you've got questions, you should definitely be seeking legal advice on, because it's a minefield out there. And that does segue into, so I told you earlier that as your employees have no First Amendment rights in the private workplace, and you as employers are free to restrict political discussion from the workplace. I mentioned there was one or two exceptions. Well, the NLRB, under the NLRA, there is, that's one of those exceptions. So as Tamsin said, employees have what are called Section 7 rights under the National Labor Relations Act. If you've been here to any of our previous seminars, we've talked about social media and the manner in which and the extent to which the National Labor Relations Board has insinuated itself into protecting the rights of employees in a union employer, but even in a non-union employer. So all employers are subject to the restrictions of Section 7, which restricts your ability to, which gives workers the rights to communicate in what's called concerted activity over workplace issues, compensation, terms and conditions of employment. So how does that impact the discussion of your ability to regulate the extent of political discussion in the workplace? The general rule, as I told you before, still applies. No First Amendment rights. You're entitled to, you have the right to restrict political discussion from the workplace. However, in certain circumstances, since the NLRA protects employees' rights to communicate about issues relating to wages, hours, and the terms and conditions of employment, you take that concept and you lay it or overlay that onto political discussion. So the Section 7 rights will impact your ability to restrict political speech about issues relating to protected topics under the NLRA. So what would that be? Example, vote for Smith, protect our wages, or support our union, vote for Smith. Those are examples of the exception to the rule. You cannot restrict your employees' abilities to engage in, or their right to engage in concerted activity, even if that involves a discussion of campaign or candidates in an election cycle, as long as there's a connection to Section 7 rights to discuss and engage in concerted activity about wages, hours, and the terms and conditions of employment. So if an employee came in and said, with a shirt or a sign that said, vote for Smith, you could restrict that if you had a policy. Comes in with says, vote for Smith, protect our wages, you would be running afoul of Section 7 and Section 8 of the NLRA if you restricted that kind of political activity in the workplace.
Gary, what if you said, take off the vote for Smith part, but you can still wear a shirt that says protect our wages?
You certainly can.
You could, okay.
Yeah, I think that's a fundamental Section 7 right for workers to do that.
But you could tell them, take off the vote for Smith part.
Well, in that connect, no. If an employee
so?
came in or posted a poster or came in with a banner or something that's vote for Smith, protect our wages, or support our union, vote for Smith, that would be, in my view, that would be protected.
Altogether, including the vote for Smith part.
Right.
And if two employees are talking back and forth about candidates with regard to protecting wages?
Sure. Sure, there could be, goes to the lunchroom discussion that we talked about, or any discussion in the workplace. If workers are talking about candidate so-and-so will be better for us because he or she supports a higher minimum wage, or he or she is more union friendly and will have better union rights, better organization rights to organize, run a union organizing campaign because this political candidate will support those views, that's all protected conduct. So that's an exception to the general rule. So what can and should employers do with respect to this topic, especially between now, May 12th, and the election in November? Consider implementing a written policy that prohibits, restricts political discussion and expression in the workplace using company assets on work time. Tie that restriction to conduct that harms productivity in the workplace and or impacts customer relations. Include a carve-out for the NLRA activities, which I went through on the previous slide.
And just, Gary, one point before you turn, that second bullet about tying the, can you go back one? Tying the restriction to conduct that harms productivity. If the employees are engaging in discourse about protecting wages, and I like this candidate for that, and it's harming productivity or inhibiting productivity, you can limit it to certain times or locations on the premises. You don't just have to allow employees to have this discourse, even under the NLRA, anytime they want, as long as it doesn't impact the workplace productivity and what's going on in operating your business. You may have to allow them to do it on the premises in a certain area or a certain time, but if it's impacting the work productivity, you can restrict it.
You can, excuse me, you can do that proactively, as in ahead of time say you can talk about these things at lunch or at this time, as opposed to waiting for it to happen and then.
Right, I'd say, yes, I would say, that would be a very fact-specific situation. What type of business do you have? How is it really going to impact productivity? So you'd want to really go through the analysis. If I put this restriction on, is it really fair and reasonable, and is it limited to a period of time where it's not going to impact productivity, and if they do it any other time, it would. So you want to be careful there. But yes, you can. You could designate areas where they can go and talk about these things without, if you're on a line working on cars and things are moving very fast, you don't want them having this kind of discourse. They're concentrating on their job.
So and the other interesting issue there is, because we talked about productivity in the workplace, is also the issue of impacting customer relations. So if you have employees who are in a customer-facing position, working on a counter selling parts or selling, facing customers at a sales position, and they come in wearing, with a button, vote for Smith, protect our wages. Smith is associated with one particular political party rather than another. Can you restrict that? Because in a customer-facing role, you may be, listen, we are politically, vis-a-vis our customers, we're politically neutral. We don't want to be seen as supporting this party over that party. So my view would be, I'd ask Larry if he has the same view, that although employees have their Section 7 rights, it's fair to give consideration to the company's, your business's relationships with your customers, and to restrict that in a customer-facing position, because you don't want to, it's your business and you don't want to alienate your customers along political lines. So employer actions, we would suggest, or strongly recommend that you train your managers as soon as you can, or get some discussion out there, get some training out there to your managers sooner rather than later, particularly as we're heading into, as things head into the general election campaign, part of the campaign. Consistent enforcement is critical. You don't want to be in a situation where you have an employee saying, well, my co-employee gets to talk about that candidate or that political issue. I'm on the other side of that issue and I'm getting shut down, I'm getting restricted in that. So if you're going to apply, if it's in your interest and you want to have a restriction on political discussion in the workplace among your employees, make it consistent as to all sides of all issues, all parties. In Massachusetts, time off for voting. The Massachusetts statute gives employees up to 2 hours to vote after the polls open. The statute says if requested, presumably if requested in advance, although it doesn't say how much time in advance. And even though the statute that I'm quoting is related to particular manufacturing. I mean, there's a limitation on the kinds of employment, but I think it's fair to say that across the board, employers should, to be consistent with the Attorney General's guidance, provide employees time off to vote on election day. It does not have to be paid time. It can be unpaid time. But you should have a policy about that. You should have it in writing. And you should, ask your employees to tell you if in advance, so you're not caught shorthanded in any particular critical function for the 2 hours after the polls open. Now on the employer side, as employer, you are restricted in Massachusetts. There's federal election campaign laws on this, which are a little bit not quite as blanket protection, but in Massachusetts, for your Massachusetts employees, you are prohibited from attempting to influence an employee's vote or political contribution.